Okay, there we go. Yep, that worked.
Okay. Oh, that's interesting. I didn't need a password at that point, so don't know.
Did we already confirm our Spanish interpreter? I wanted to follow up on that.
Yesterday, yes.
Okay, got it.
Yeah. So if I go to view and go to speaker. So Guthrie?
Yes.
For the student panel, what do you think? Multi-speaker instead of gallery? I'm not going to use gallery for anything, I don't think.
Okay.
Right.
I'm not super familiar with multi-speaker,
Okay.
but I guess that makes sense.
Okay, okay. Okay.
We wanted to ask one question just for clarification, if you don't
Yes.
mind.
Of course.
Yeah, yeah.
So, because all meetings are so different. So for
Yeah.
this meeting specifically, just to clarify, there's not noted deaf participants, you know their names, you know who they are. It's
Right.
just a free for all. Anybody can join if they want. So there might be deaf, there might not be deaf. You're not sure, but we need to interpret through the whole thing anyway, regardless either way. Is that correct?
Okay, good morning, everyone. Thank you so much for coming here and joining us at 9 o'clock on a Saturday morning. Very exciting set of workshops and speakers and whatnot that we have here today. Very briefly, I am Guthrie Fleischman. I am the SELPA Director for West Contra Costa Unified School District. Want to introduce a couple folks first and foremost. Huge amount of gratitude to Janine Bishop, who is here. She's our parent liaison who put everything together today. I also want to introduce our school board president, Jamila Smith Folds, who is here joining us today, as well as our retired SELPA director, Steve Collins, who was just here, and I think he dropped off, but should be back briefly. We do have, oh, there he is. Morning, Steve. We do have both ASL and Spanish interpretation available, so if that is needed. For Spanish interpretation, look to the bottom of your screen. For ASL interpretation, there is an interpreter who is already active, and you can pin her window on your screen so that you keep her always highlighted during the entirety of the time. Before we get started, I want to read our land, labor, and body acknowledgement, as we do in all meetings in our district, as we move forward with anti-racism and anti-racist practices and developing a different lens for the way that we view the work that we do and just living on lands that are not our own. So our land acknowledgement is that we recognize that we are presently on the lands of the Chochenyo, Muwekma, Karkin, Ohlone peoples and acknowledge them as the first inhabitants of the land we currently occupy. And our labor and body recognition, I acknowledge that the burden of environmental exploitation and systemic injustice falls upon the labor of Black and brown bodies in the building of this country and its institutions. I remember that Black and brown people were born and died working this land against their will for generations. I also acknowledge the continued contribution of the labor of survivors over the centuries to today, of all immigrant labor, including voluntary, involuntary, trafficked, forced, and undocumented peoples in the building of what we refer to as the United States. And so without any further ado, I want to get us into our first incredible workshop. I want to introduce to you all someone who I have gotten to know a little bit over the last couple of years, who has been an incredible resource to families and to our district, and who is going to take you through parents' rights and procedural safeguards. Please welcome Ms. Tonya Saheli.
Thank you so much, Guthrie. Thank you so much for having me. I'm going to jump right into my presentation because we don't have a lot of time, but I have a lot of information. So I'm going to jump right in. If you have any questions or comments, please put them in the chat. We will try to get to them at the end, but I've done this type of presentation before, so I know the kinds of questions and concerns that usually come up. So I also have a link to a resource that you can click on and maybe answer some of those questions that you have, okay? So we're gonna jump right into it. So can everyone see my screen? Yes. All right, so today I'm gonna be talking about parent rights and procedural safeguards for students with disabilities receiving special education services. So Um, really quick, the overview of the training, we're going to look at what exactly are procedural safeguards. I know that's a big word that is used a lot, but sometimes parents don't really know what that means. So we'll look at what procedural safeguards are, what laws govern those procedural safeguards. The second level of the training looks at what you should think of when you hear the word procedural safeguards. And then last, we'll wrap it up with what exactly are parent rights and responsibilities in California under the special education laws. All right, so in special education, as you all know, there's a lot of word salad that is sometimes made and with abbreviations, and people don't really understand. So I provided an abbreviation glossary really quick. You'll hear ADR a lot when speaking about procedural safeguards under special education. So ADR just means alternative dispute resolution. It's a different way that you can resolve a matter. And it is one of your rights under the procedural safeguard rules. CFR is the Code of Federal Regulations. These house a lot of the special education laws that get translated into procedures for parents with children in special education. CEC, that's the California Ed Code. This is also a place where lots of laws, rules, timelines, things that you need to know are housed. So if you hear CEC, I'm talking about the California Education Code. FAPE. I know that you all hear FAPE all the time, and you probably already know that this means free, appropriate public education. Free, appropriate public education. This is on appropriate, right? And so whenever your child is going through the IEP process and FAPE is mentioned, you should automatically think about appropriate is what is happening, appropriate. Also free, right? So we'll talk about that a little more. Then we have IDEA, Individuals with Disability Act, IEP, Individualized Education Program, OAH, Office of Administrative Hearings, SELPA, the Special Education Local Plan Area, right? We just introduced Guthrie as the director of the SELPA. So SELPA means Special Education Local Plan Area. The CDE, that's the California Department of Education. USC, that's the United States Code. And then lastly, LEA, that's your local education agency. So hopefully that helps. Take a picture of it, get familiar with it so that when people are saying these acronyms, you know what they're talking about. All right, so what laws govern procedural safeguards? Let me move. I have to move move your faces so I can see my slides here. what laws govern procedural safeguards? Procedural safeguards are outlined under federal and state laws. So I have some of the codes here. You can, if you want, take a picture of that too. And if you want, I can also provide a handout, Janine, later that you can give to parents that has a lot of this information. So there are places where you can find this information. It provides you as parents, legal guardians, and surrogate parents of children with disabilities from ages 3 to 21, and students who have reached age 18, which is the age of majority in California, with an overview of educational rights or procedural safeguards. The notice of procedural safeguards is required, right? This is not an option. It is required under the IDEA. Remember, we just said that stands for Individuals with Disabilities Education Act. And it's required in English or your native language, and it must be provided to you in several different at several different times. Okay, so we'll go through each time. You should be provided with this these procedural safeguards. Okay, so we already went over the definition. So let's see. When should you be provided with procedural safeguards? Once a year. When you ask for a copy, maybe you lost it, right? So even if you've been given a copy before and you need another one, it should be given to you. When you request an evaluation, at the first occurrence of a mediation or due process proceeding, the first time your child is referred for a special education assessment, each time you are given an assessment plan to evaluate your child, upon the receipt of the first state or due process complaint in the school year, and when the decision is made to make a removal that constitutes a change of placement. These are all the times where you should be given the notice of procedural safeguards. Now, if you don't understand what is being given to you, guess what you can do? Guess what your right is? You can ask for a verbal explanation, right? How many of you just think you don't have to raise your hands? But how many of you have gotten procedural safeguards and didn't really understand what they meant, right? How many of you knew that you could ask for a verbal explanation? Well, guess what? You can, okay? So, talking more about the IDEA, Individuals with Disabilities Education Act. I don't know if you could see. There it is. I was going to give you an opportunity to tell me what it was, but we don't have a lot of time for participation. So I'm just going to tell you what it is, right? IDEA, it's a federal law that requires school districts to provide free, appropriate public education to eligible students with disabilities. So it encompasses a lot. But it means that special education and related services are to be provided as described in your child's IEP and under public supervision to your child at no cost to you. So again, I pose you with the question, what should you think of when you hear the term procedural safeguards? Just think about that, right? You shouldn't be afraid at all, but you should know something should come to your mind when you hear this term. Most simply put, I implore that you, when you hear the term procedural safeguard, you think of it as your rights, right? Something that houses your rights as parents of students who are in the programs the special education programs at the schools where your child attends. So this term is synonymous with parents' rights. As long as states follow the overall process in the IDEA, they have leeway to determine some of the details. So the IDEA is a federal law, federal rules, and then states like the CEC, they have their laws. But as long as the states follow the overall process in the IDEA, they have a little bit of leeway to determine some of the details. So you all live in California, so you are governed by California laws. Again, IDEA is a federal law. So California laws can't contradict it. And they cannot even be less stringent, but they can be more strict, right? So you might have a sister or brother or a family member who lives in a different jurisdiction, a different state, and they're telling you about their procedural safeguards in that state, some of the things that they've been afforded under, say, Oregon. And you're like, well, I'm going to go back and I'm going to talk to, my school and my SPED team because we don't have that right. Well, guess what? Just because your cousin's child is getting some services in Oregon doesn't mean that you have the same rights under California because it's different jurisdictions. So you have to get comfortable and familiar with California procedural safeguards, because although IDEA is federal and it guides all the states, California has more stringent, specific rules that apply. So they are likely different from other jurisdictions, okay? Now, I think I already asked you how many of you read the procedural safeguards when they are provided. And I don't know if you know how to use your little icon, or you can come onto camera and raise your hand, I guess. But really think about if you've ever read them. I would like to know, and you don't have to tell me, but if you're shy, I can't see you anyway. Did anybody respond? I can't really see.
I don't see any responses in the chat right now.
Okay, well, just think about it. You don't have to tell me, but just think about if you've ever read them thoroughly, okay? And then I'm going to tell you why you should. You should always read the procedural safeguards each time they're provided. And the reason why is because they change, right? I also have the privileged opportunity to go down to Legislation Day every year to help lobby for different things to be put in place and different laws to be passed. So when those laws are passed, it might affect how the procedural safeguards look for you. And if you're not reading them every time, you might be missing out on understanding what some of your rights are. So you definitely should be reading those procedural safeguards every single time and understanding them. Okay, I was going to have you do an exercise. Right, to try to understand how many procedural safeguards you're familiar with and that you've utilized in the past, but I don't think I have time. So I'm just gonna go to the next slide and I'm gonna front load these procedural safeguards for you. What exactly are parents' rights and responsibilities in California special education? I'm front loading them. Here are 13. This is the list of 13, okay? You have the right to participate, and then I'm going to go through each of them as time permits. And we'll talk about what that means. What does that mean, you have the right to participate? You have the right to receive prior written notice, okay? You have the right to consent. this one is big. This one sometimes holds up a lot of progress in the IEP process because there's a lot of ways that different school districts interpret what does it mean for a parent to have the right to consent. So you need to understand what that means. So we'll talk about it. You have the right to refuse to consent, right? Sometimes parents don't feel like their child is a candidate for an IEP, and they don't want certain assessments done. So they have the right to refuse, but there's a process to it. You can't just, say, I don't want it, and then, not follow the process. So we'll talk about that. You have a right to be given a non-discriminatory assessment. So, there was, and we'll talk about more in detail what that means, but there was a particular school district that I actually do work with, where a landmark ruling came down from the courts because parents felt that their children were being given a discriminatory assessment that qualified them for special education. And so, they exercised their rights to have a non-discriminatory assessment. And now that is law, and that's one of the procedural safeguards. You also have a right to receive an independent educational assessment, also known as an IEE. This also is a point of contention oftentimes in some of the cases that I am brought in on. So we'll talk about that. You have a right to access educational records, right? You have to follow guidelines, but you have a right to it. You have a right to stay in the current program if there is a disagreement about placement. This is often spoken about as stay put, right? I'm pretty sure you're familiar with that. You have a right to be given a hearing regarding disagreements about an IEP. You have a right to receive mediation. You have a right to file a complaint against your school district. You have a right to be informed of school discipline and alternative placement. And you have a right to be informed of policies regarding children who attend private schools. All right, so the first one, the right to participate. What does that mean? Parents, you are a part of the IEP team, right? You're not to speak about IEP team as if you are not an active participant. You are. You have a right to refer your child to special education services, also to participate in the development of the IEP and to be informed of all programs, the options, the alternatives, both public and non-public. But if you're not exercising your right to participate, then that's a problem, right? You must be given opportunities to participate in decision-making meetings regarding your child's special education program. Once parents, I found that the IEP teams that work or function the best are those that understand this parent-school district relationship as being almost symbiotic, right? You all should be working towards a common goal, and you all should look at each other as participants on the same team. All right. I mean, I could say so much about this, but time is of the essence. I will say that the local education area also must ensure that if a parent is not available to participate, then an individual who is assigned to act as a surrogate parent for the for the parents of a child with a disability is identified, and they are an active participant. So just because of, you might not be able to be an active participant, there could be or should be a parent, surrogate parent, or someone appointed if the child is homeless youth, an adjudicated dependent, a ward of the state, et cetera, et cetera. So parental participation or a surrogate is your right, and it is very essential to the success of your child. The next, I kind of went ahead of myself. Let's see. What else can I say that I didn't already say? Oh, in terms of participation, you also have the right to electronically audio tape the proceedings of an IEP meeting, but you must give the school district notice at least 24 hours prior to the meeting. The parent or guardian shall notify members of the IEP team of your intent to record a meeting, right? So then that will give the district time to and if the parent or guardian does not consent to the LEA audio tape recording of a meeting, then the meeting shall not be recorded, right? So you have the right to request a recording, and you also have a right to refuse to allow the recording, right? If you don't want it recorded, then it's a two-way street. Your rights include information about the availability of FAPE, including all the program options and all available alternative programs, both public and non-public. All right, so that's the right to participate. Now, what about this right to receive prior written notice? There are several times where you should receive prior written notice, and I think I might have already mentioned that, right? But you have to receive prior written notice in your native language when the school district initiates or refuses their request to initiate a change in your child's identification, assessment, or educational placement in special education. So it must be in your native language. Okay. What about consent? What does this mean? Well, under both federal and California law, parents, you must provide informed written consent under the following scenarios, right? Before your child is assessed or provided with any special education services, and before any change in special education services occur. The district has to ensure that you understand the IEP proceedings, the proceedings of the IEP team meeting, including arranging for an interpreter, right? So even for this goes for parents who are deaf, right? So like right now we have examples of that happening right now. We have someone interpreting in sign language, and I believe we might, correct me if I'm wrong, Guthrie or Janine, do we have someone interpreting in Spanish or anything right now?
Yeah, we do. Mhm.
Okay, so
I'm sorry, I'm interrupting. This is Nabila Anjum. I'm also Urdu interpreter, and I'm not
Okay.
sure if mom is here, who's translating for.
okay. Do you know the name, or can someone?
Mr. Mackenzie Martin. I receive email from them, and then mom name is Aruba.
Yeah,
That's
I will message you in the chat if she comes on. Thank
Okay,
you.
Thank you.
so I love this. This is real time accommodations, right? Happening, and this is your rights, parents. You have a right to understand what is being said in the means, the language, the mechanisms that you need those things to be translated to you. So if you ever get to a meeting and you find that there's no method for interpretation, then that meeting needs to be rescheduled, because it's your right to be able to understand. Otherwise, how can you consent to anything if you don't understand? Now, under federal law, so here's a difference between federal law and California law. And this may be a situation where, excuse me, you might, if you're talking to someone in a different state, you might find that there are some discrepancies, but it doesn't mean that that your district is doing anything wrong, right? It means that they're abiding by California law. So for example, under federal law, new services may be implemented without consent. That's federal. But California has made this rule a lot more stringent. And under California law, no new services can be implemented without parental consent. So if you see that there has been something implemented and you didn't consent to it, that's a violation of your right to consent under California law. All right. Remember what we said, California cannot contradict a federal law. So at first glance, you might say, oh, well, that's a contradiction, because federal law says new services may be implemented without consent. California says no new services. At first glance, that might look like a contradiction. But if you understand the relationship between federal law and California law, where California can't be less stringent, but it can be more, right? It can be more strict. So that's an example where it's more strict. Okay. So that's why it would be okay. Parents, you need to understand that there's a difference between IDEA, federal law, and California law when it comes to asking for consent. So under both, under the IDEA, the school must ask for your consent 3 specific times before the school conducts an initial evaluation or reevaluation, before the school provides services to your child the first time through an IEP, before inviting non-school agencies to participate in IEP meetings to discuss your child's transition to adult life. So this is IDEA, and you must give permission in each situation above. Okay, but remember, California as a state and your local schools may have rules requiring informed consent at other times as well. So they can add to these. But right now I'm talking about IDEA in California. If the school takes none of these actions, or I'm sorry, one of these actions without getting your consent, you have 2 options. You can ask for a due process or file a state complaint. Now, those are like the most stringent options that you have available. Now, I'm an advocate for ADR. So I know for a fact that ADR works, and that's also along the continuum, the special education continuum, the your procedural safeguards, rights to ask for a meeting. You don't necessarily have to go from 0 to 100 in 30 seconds, asking for a due process or filing a complaint. Maybe this is a situation where the school needs a little bit of grace and something was overlooked unintentionally. You can ask for a different kind of meeting, ADR meeting, to get this thing rectified. And then if you see that, oh, this isn't working, then just off the record, I would say, then you can ask for a due process or file a state complaint. But if you feel like, you don't want to waste your time, you feel like it's not, this has happened before, then by all means, exercise your rights to due process or file a complaint. But I'm just saying, there are other ways to get this done that can happen much more quickly and in a way that keeps your relationship together. Because like I said before, you're a team, you're a part of the team. And, you know, sometimes you have to give and take to keep for the sake of your student. Okay, that's just a little side note. All right, so you also have the right to refer your child for special education. You have at least 15 days from the receipt. Okay, let me go back. You must give informed written consent before your child's first special education assessment can proceed. And then you have 15 days from receipt of the proposed assessment plan to arrive at a decision. Okay, so the assessment is done. You have at least 15 days. The assessment may begin immediately upon receipt of consent and must be completed and an IEP developed within 60 days of your consent. So this is where things start to get a little murky in terms of the timeline. So it is incumbent upon parents to keep some kind of tracker so that they understand the timelines, because it gets tricky. There's a lot of dates and times, and you know, you must do this, and you have 15 days from receipt of the proposed assessment plan to arrive at a decision, right? You don't want to exceed that time, because now you've lost that right. So you just want to make sure you're keeping up, excuse me, with the timelines. If you do not provide consent for an initial assessment, or you fail to respond to a request to provide the consent, the school district may pursue the initial assessment by utilizing due process procedures. So this is another place where I want to put a pin in it and emphasize that it does not serve your child to ignore or fail to respond, I will say. Because if you don't provide consent, the school district can still take action. If you refuse to consent to the initiation of services, right? If you refuse, now you're taking action. You're putting it in writing, I refuse. Not the non-response, right? But the actual action of, I refuse to consent to the initiation of these services. Now the school district must not provide special education and related services, and they shall not seek to provide services through due process procedures. That's only if you take affirmative action and actually refuse to consent. But again, if you just let time pass and do nothing, that's called a failure to respond to the request to provide consent. And the school district has the right to provide the initial assessment by utilizing due process procedures. So parents, you definitely have a bunch of rights, but you have to know that the school district also has rights. So you want to make sure you're exercising your rights so that none of your desires or concerns for your child is usurped because you didn't do anything, okay? So again, what happens when a parent refuses to consent to an assessment of their child in special education? If you consent in writing to the special education and related services, but do not consent to all of the components of the IEP. So I don't know, maybe you've heard of a situation where your student has been involved in the IEP process, and there's some services that were presented and you did not agree with. You didn't agree with some of them, but you did want some of them to happen. So those components of the program to which you have consented must be implemented without delay. So this is also known as agreeing with exception. Sometimes parents say, I'll sign that, I'll consent to only this, but not that. that's definitely your right. So just know that you don't have to consent to everything, but for the sake and best interest of your child, if you agree to some of the things, you should agree and consent in writing so that those components of the program to which you have consented can be implemented without delay. If the school district determines that the proposed special education program component to which you do not consent is still necessary to provide FAPE or free and appropriate public education to your child, then they can still initiate a due process hearing. Because remember, you're a team, and even if you don't agree with it, the school district's right is to provide a free and appropriate public education. So some of the things that they have listed, they might feel like, you're not agreeing, maybe you don't understand, but it actually is appropriate for this child that we as a team are in charge of providing the best education. So they might have to initiate due process. If a due process hearing is held, then that decision is final and binding. So again, before you get to that, and sometimes I do a training, it's called the ADR continuum, and it shows things that you can do on the front end versus those things downstream. I would say, it's almost like going to court and having a judge decide. You don't have a lot of say in that versus having a mediated situation where negotiation can take place and you can have a conversation about things. Why don't you, maybe it's just a disagreement. Maybe it's just a misunderstanding. Maybe it's terminology being used that you don't understand. So before that district takes this process or these different things that they would like to see implemented to provide your child with FAPE, before they go to due process, wouldn't you think it would be more advantageous to have a conversation where you can affect the decision versus a final and binding decision? That's just a side note, but sometimes it's necessary. In the case of reevaluations, the school district must document reasonable measures to obtain your consent. And then if you fail to respond, the district may proceed with the reevaluation without your consent. Okay. You also have the right to revoke consent. If you sat in a meeting and you decided, okay, let's go for it, but I really didn't understand, or whatever the case may be, anytime subsequent to the initial provision of the special education and related services, you can revoke consent in writing for the continued provision of the special education and related services. This will result in the school discontinuing the special education and related services to the child, but the school has to provide prior written notice before they take away the services. Remember, we went through a list of when prior written notice is required. So even if you revoke the consent, if the district takes measures to stop the services, they have to provide you with prior written notice. Also, the school may not use procedures such as mediation or due process in order to obtain agreement or ruling that the services may be provided to the child, okay, after you revoke consent. If you revoke consent, then the school district, the public agency, will not be considered to be in violation of the requirement to make FAPE available to the child because of a failure to provide the child with further special education and related services. So what that means is you as a parent, guardian, surrogate cannot revoke consent and then say, you all didn't provide my child FAPE. Well, you've revoked consent. And again, remember, under California law, it's very strict. Services cannot be implemented without your consent. So if you revoke consent, can't have it both ways. Can't revoke consent and then claim that there was a lack of FAPE offered to your child. The public agency is also not required to convene an IEP meeting or develop an IEP under the Code of Federal Regulations for your child for further provision of special education services. Also note that if you revoke consent in writing for your child's receipt of special education services after the child is provided special education services, the agency or the school district is not required to amend your child's records to remove any references to your child's receipt of special education and related services because of the revocation of consent. So if they've already started the services and it's in your child's record, just because you revoked consent, they're not required to change or amend your child's education record under law and remove anything that had anything to do with those services. All right. Remember, we talked about the right to be given a non-discriminatory assessment. And so, as I was mentioning before, in San Francisco Unified, there was a large landmark case, the case of Larry P., that found that 5 African-American children have been placed in special education classes for the educable mentally retarded in SFUSD. They filed suit in Federal District Court of Northern California, claiming that their children had been wrongly placed in the EMR classes based on their performance on intelligence tests that were racially biased and discriminatory. Now, there has been efforts to overturn Larry P. I'm not really sure where those efforts are, but I'm talking about something that passed in the past. Now, like I said, people are coming together. I was actually consulted with about these efforts to overturn Larry P. But Larry P. is an example of how this particular procedural safeguard, the right to be given a non-discriminatory assessment, came about. Okay, so just make sure you know that that's your right, and if you feel like things are happening that are discriminatory, then you have the right to speak up about it. The right to receive independent educational assessment. So this is the IEE, and I know sometimes parents hear from other parents that you have a right to an IEE, but I think it's very essential that you understand what this actually means so that you're not requesting an IEE at a time when you shouldn't be, right? So there's rules to follow under your rights. So if you disagree with the results of the assessment conducted by the school district, you definitely absolutely have a right to ask for and obtain an IEE at public expense. But it's only one IEE at public expense each time the LEA, the local education area, conducts an evaluation which the parent disagrees. So one IEE at public expense each time the LEA conducts an evaluation which the parent disagrees. So let me give you a good example so that you will remember this. If you agree with the evaluation that the LEA conducted, you are not eligible for IEE at public expense. Why is that? Why do you ask? Because you agree with it. The rule is you're entitled to one IEE at public expense each time the LEA conducts an evaluation that you disagree with. So you cannot expect the LEA to pay for an IEE when you've already said you agree with the assessment, right? Now, if you want to go ahead and get your own assessment done, that's a different story. But we're talking about at public expense, right? And this is a area where I see a lot of problems come up because, you know, parents are misinformed sometimes. Some of the other parents may understand the right to an IEE, but they haven't gone through with the conversation and shared, you know, that the parent has to disagree. And so sometimes parents get into the rooms, have conversations, and the question comes up, well, do you agree with what the assessment? And they say, yeah, but I still want an IE at your expense. And, you know, the powers that be say, absolutely not. Just that you agreed. And they don't understand why. So hopefully I'm clearing that up for you. When a parent requests an IE at public expense, the school district must, right? One that you disagree with. The school district must without unnecessary delay, either ensure that an IE is provided at public expense or request a due process hearing if the district believes their assessment was appropriate and disagrees that an IE is necessary. So remember, we're going through all of your rights, but I think it's also important to understand what the district's rights are in a particular situation so that you can remember within this relationship that you have, that you're partnering with the district to participate for your child. You need to understand what your rights are, but you also need to understand what the district's responses can be and what their rights can be legally to your responses. So if they believe that their assessment was appropriate and they disagree that an IE is necessary, they have a right to establish the standards or criteria for IEs at public expense, and they have a right to request a due process hearing. Okay. All right. What about educational records and access? You have a right to inspect, review, and obtain copies of your child's records, educational records. So that one is pretty straightforward. And, you know, the district must comply within a reasonable time. Okay. You also have a right to stay, for your child to stay in the current program, which is also called stay put, if there's a disagreement about placement. If you disagree with the district regarding your child's special education placement or a proposed change in placement, the law requires that your students stay put in the current program until the dispute is resolved. Okay? That one is also pretty straightforward. You have a right to be given a hearing regarding disagreements about an IEP. Right? You have a right to present a complaint relating to the provision of the FAPE for your child. You have a right to an attorney, an advocate, and the student, if appropriate. They can be present at the due process hearing and to make the hearing public. Under certain conditions, the hearing officer may award, reduce, or deny the reimbursement of attorney's fees and fees paid to non-public institutions by parents in the settlement of a case. Right? So to request a due process hearing or receive complete notice of procedural safeguards regarding due process hearing, there's a wonderful, you can contact the Office of Administrative Hearings, but there's a website that you can also go to and you can find out how to contact the OAH for that. Okay.
Tonya,
Yes.
I just want to interrupt and give you a timestamp and let
Okay.
you know you're at 9:52.
Okay. All right. We'll try to go faster.
Okay.
Okay. You also have a right to mediation. So mediation sometimes is confused with ADR. ADR is not the formal mediation. It's a type of resolution meeting. So I'll talk about that right after this. But you do have a right to engage in mediation if you are if you have a disagreement, you can request mediation regarding your child's special education program. And it's through voluntary mediation. And both parties have to agree. The process through which parties seek mutual agreeable solutions to the dispute. And your school district has those resources available. But you can also contact the CDE or the OAH if you want to participate in formal mediation. You may seek mediation alone or separate from due process, or you may participate in mediation pending a due process hearing. Now, mediation and due process, right? Remember I told you there's a continuum. You have things that you can do on the downstream and things that you can do on the upstream. More, less involved, less contentious, less formal versus, going all the way. I would say mediation and due process is like going all the way. But there are certain things that you can do before you get there, and you have a right to do that. Because some parents, just aren't contentious. They just aren't litigious, but they just really want what's best for their child. So they would prefer to do something more on the upstream where, it's not so formal. And that's where ADR services come into place. You have a right to ADR, alternative dispute resolution. This can happen even before mediation and due process. And it should be something that you always have on your mind because the results are quick. You are participating in the results, and you're not going through this formal process where you're having someone decide the fate of your child with no say. And that's what due process is. It's very formal. ADR, our alternative dispute resolution, is where a neutral third party helps facilitate an IEP or a conversation between the parent and members of the special education team. And you would need to check with your district regarding these services. And then, real quick, you have a right to file a complaint against your school district. You have a right to be informed of school discipline and alternative placement. You have a right to be informed of policies regarding children who attend private schools. So, who should you contact about an IEP concern? When you have a concern about your child's education, it's important that you talk to your child's teacher, content specialist, administrator, and you can talk to folks who oversee your SELPA staff in the school district. Every school district has different terminology that they use, but I would just advise that you reach out to Janine. Is a great resource. If you have an IEP concern and you want to engage in any ADR services, or you want to take it to the next level, please contact Janine. And I will also put a link in the box for questions around IEP timelines and things like that. So you can bookmark it. It's straight out of the Ed Code, and you'll never forget when you should do X, Y, and Z. All right, so I know I'm at like 9:57. I'm going to stop sharing, and I'm going to put this link in the box, and I'm hoping that I said something that was helpful for you all today. Thank you very much.
Thank you so much, Tonya. We do have a few questions from the chat
Okay.
that I would love to have you address.
Sure.
I see, do both parents have to consent to an assessment? I see the AP requires one signature. Also, At the initial IEP, what if one parent doesn't want the child to receive the services? And if the other consents, do we proceed with providing services?
So it depends on the relationship. Who has the parental rights, right? That is who should be consenting. There's oftentimes situations where there's custody agreements, and those parental rights are listed in custody agreements. And so the school district must understand what those rights are in terms of the parents who has the ed rights, and they're the ones who consent. It gets very, very murky depending on what the relationship is. So it is a case by case basis, but I would say a general rule is whoever has the parental rights is the one who consents. If it's both parents, then they should both consent. But if there is a disagreement, then that has to be hashed out before you can even get the school district involved, because you also don't want to violate any custody agreements. So if there's a custody agreement on file, if there's something in the file that says dad also has the right, then the school district must refer to that and then act accordingly. What was the other question?
Okay. Oh, on that one, sorry, there are a few more questions too I want to get
Sure.
to. No, actually, that actually wrapped up that entire question. Thank you.
Oh, okay.
Okay.
I'm gonna put this link in the chat though, so that you all can refer to it before my time is up.
Okay. We also have, do SLP and school psych, probably others as well, need to provide lists of assessments to be done.
Does school sites need to provide a list?
Of assessments
So
to be done, right?
it depends on what the IEP process, the part of the IEP process that you're involved in. If you've discussed and agreed to it, then definitely they should provide what the assessments are. Now, if you want to just know what assessments are available, I think that's a side conversation. Is it a requirement? I don't think that they have to just list all of the assessments that are available, but if you request it, they should.
Okay. And then this one, I think most of us do know the answer to this, but is it okay to email parents digital copies of the procedural safeguards, or does it need to be paper copies?
So normally it gets tricky emailing things. So I think that, Janine, how does West Contra Costa do it?
Guthrie, are you on here?
Yes, it is okay to email procedural safeguards, but it should also be provided as a hard copy as well,
As a
upon
backup.
request. And we can't make an assumption that one or that a digital copy will be sufficient, unless you've confirmed with that family that they can access in that way. You know, some folks may
Yeah.
have an email but not a printer or whatever the case. So just make sure that they're able to receive it in multiple modalities.
Yeah, and I think if you are comfortable with that, then definitely, but it shouldn't be taken for granted that a person has access, right? We're talking about access and being able to access the information, and some people don't know how to use. So some people don't even have an email address. They don't know how to use a computer or open attachments. So I think the safest thing to do is for a conversation to be had is if that is what that family wants.
Okay, and then two more quickly. Does the educational records request include emails related to your child?
Is that a record? So record you can get very legal about what constitutes a record. Emails regarding, okay, so I'm trying to stay out of the legal advice realm. I would say that emails regarding your child is not necessarily a record. What the law is speaking about when it comes to a record is what is in the, what's the name of the electronic place where you keep this? What's it called?
SAIS, Special Education Information Systems, SAIS.
Yes. So yes, SACE. Whatever is in that particular housed in that particular place is what is considered the record. That other like emails and stuff, that's a type of record, but that's not a record for purposes that are defined in the Ed Code. That's my answer.
Okay, and I know we need to move on, but I have, we do have an IEE question in the chat.
Okay.
Does the IEE include testing all areas of suspected disability that the parents didn't agree with in the district assessment reports? That's the first half of the question.
All areas?
Yes. Does it include all areas of suspected disability that the parent did not agree with in the assessment reports?
All areas that the parent did not agree with. It wasn't an assessment of the child.
That's the intention for the IEE request.
I would think that just looking at, a broad read of the law, it contains or pertains to assessment that had to do with the child in the IEP process that the parent disagreed with. So again, remember what I said. Even if you believe that you should get an IEE on this, the school district definitely can push back and say, no, that doesn't apply, right? And so I think when you get to those, you start to get into the weeds, that's where you get into a situation where the district can always say, we don't agree with that, right?
Okay.
But it's really those areas that are not questionable. This assessment was done on my child. It said X, Y, and Z. I disagree. I would like a independent assessment at your expense.
Okay, and then the second part of that is, does the parent have to use the district's IEE list to have the further assessments completed, or can they find an independent assessor?
That's a great question. I think, is there a reason, right? I think that comes down to, do you feel like the list is biased or anything like that? I don't know that you have to. It's almost like how when you have an insurance claim and you go and the insurance company gives you a list of repair companies because they work with them. But if you know someone else that is highly qualified, they have the credentials, I think that's a conversation, right? But I think it's first more related to why do you want to go out and seek a new someone else when there's resources here? Is there a trust issue, right? That's just not a straightforward answer.
Right.
That's a conversation. Yeah.
Okay. And we have one more question, and then we're going to switch to our next presenter. And this one is, if you request an IEP assessment via email in September of 23, and the request is ignored until April of 24, you cannot file a complaint because the request was via email? Do you see that in the chat?
Yeah, I see it, and I don't know. So was this something that someone said you can't do? Has this been explored? Was it told to the parent that they can't file a complaint because the request was in email?
That shouldn't be the case.
Yeah, I don't understand why would they think that they can't file a complaint because the request was in email?
Yeah.
I'm actually going to step in on this one. I'll put my email in the chat, parent. Please send me an email and I will direct you to the appropriate person to follow up on that. Any request via email or any request in writing is a valid, even a verbal request is a valid request and starts the timeline. So I'm going to put my email in the chat. Parent, please send me an email and we'll follow up with supporting you with next steps.
Yep. Thanks, Guthrie.
Thank you. And thank you so much, Tonya, for your time. We very much appreciate and all the support that you've given families in the district over the years and
Absolutely.
getting to the appropriate outcomes for IEPs. So thank you so much for your time, and I'll pass it back to Janine to move us forward.
All right.